Very many thanks to everyone for coming along this evening. And we would like to welcome you to the fourth in this series of legal information webinars presented by a collaboration between the Ukraine-Ireland Legal Alliance and Irish Red Cross, hosted by the Irish Women Lawyers Association. This evening's topic is a very topical one, immigration law. And we have as our presenters from the Bar of Ireland and Arthur Cox. We have Angus and we have Alina. We will be hearing first from Alina and then from Angus. So moving on to our next slide. This evening, our session is regarding immigration. And our first speaker this evening, Alina Kuksenko, will be presenting from Arthur Cox. Alina, I'll pass over to yourself.
Good evening, everyone, and thank you so much to the organizers of this event and to those attending this event. It's been a pleasure to prepare for this session, and I'm very pleased to be able to present. I'll be speaking today about temporary protection and the rights it entails. Can we move on, please, to the next slide? So the Temporary Protection Directive is an EU law that was introduced in 2001, and the directive created a special procedure to deal with a mass influx of people in need of international protection. The directive was activated for the first time in March 2022 in response to the war in Ukraine, and it has been extended to 4th of March 2025, and I will add a little bit more information on the term of temporary protection a bit later in my presentation. You can download and print a confirmation notice on the Irish immigration website confirming that your status has been extended, and this can be presented as evidence of the extension along with the original temporary protection permission certificate, also known as yellow letter, and your Irish residence permit, that is IRP card. It's important to understand that the temporary protection is introduced on an EU level, and different member states have some freedom as to the level of benefits they provide, although there is certain minimum that is required from each member state. Can we please move on to the next one? So during the temporary protection period, EU member states must provide the right to be employed or self-employed in the country, access to education and vocational training, access to suitable accommodation. Currently, Ukrainians arriving to Ireland have the right to stay in a designated accommodation center for 90 days, or they can choose to stay in pledged accommodation provided by the Irish Red Cross or privately sourced accommodation. And they are also entitled to access to social welfare and medical care. First, the main right is the right to reside in a state until the temporary protection expires. When we were preparing for the webinar, there has been no information regarding the future prospects of temporary protection and what follows after the 4th of March 2025. However, amusingly enough, today, that is on the 11th of June, the European Commission has proposed to extend the temporary protection to people fleeing Ukraine due to Russia's aggression for another year from 5th March 2025 to 4th March 2026. The Commission will present the proposal to the ministers at the Justice and Home Affairs Council on 13th of June. It is then for the Council to formally adopt the proposal. By no means this means that there is a definite decision, but we will continue to monitor the developments in this sphere. As soon as there is more clarity in this regard, we're planning to hold another series of webinars to address this topic. And now I will hand over to Angus O'Corrin, barrister at law, who will speak a little bit more about international protection and its differences with temporary protection.
Thanks, Alina, for kicking us off. So if you could move to the next slide, please, that'd be great. Okay, so I'm going to talk to you about two things today. Firstly, I'm going to talk a little bit about international protection and the process involved in applying for international protection. And then I'm going to talk a little bit about what actually is international protection, because I think a lot of people hear the words international protection or refugee status, but it's not generally understood what those terms mean. And they have very specific meanings, and it's very helpful for people to know what those are if they're considering applying for international protection. Many of you, of course, won't have considered international protection because many people who've come from everyone who's come from the UK and pretty much is covered under the Temporary Protection Directive that Alina was telling us about. So what's international protection? Well, international protection is you apply for what's called refugee status, international protection or subsidiary protection status. And I suppose the first question to answer is, what does that involve when you apply for international protection? Well, the first step is you go to the International Protection Office, which is located on Mount Street, and you have to wait to do a preliminary interview. And once that preliminary interview has been done, your application for international protection has been made. At that stage, then, once you've done a short interview in the International Protection Office, you'll be required to complete a questionnaire. And that's a long document where you set out your story, your reasons why you're looking for international protection in the state, and the reasons you say it's not safe for you, for whatever the reasons may be, to return to your country of origin. Now, it used to be the case that you would be given that questionnaire to take away with you in a language you could understand, but there has been a change to the procedures for international protection, and you will now be expected to fill out your international protection questionnaire at the International Protection Office on Mount Street. You will often be facilitated and given translation services to help you fill out that form, because you'll be expected to fill it out in English, but it's a challenging and difficult to understand document. So it does, I would suggest, as somebody who has represented many clients in this area, require some consideration before you go in and apply on that first occasion. You should probably have a think about what you want to say and what you want to say in your form. Once you've completed your questionnaire, you leave the IPO office, and then later you will be informed by the IPO and you will be given a date where you come in and you do a personal interview where you will explain your reasons for seeking international protection to the International Protection Office. And I've attended at these interviews in the past with clients. And basically what happens is you go into a small room with a computer and the interviewer is there. If you need a translator to help you translate your story, because you may not speak English very well, a translator who will translate your words from your own language into English will be provided for you, and you indicate that before the interview date. So in your questionnaire, you say whether you need a translator. And then what happens is the interview asks you your story, and you have to give all the reasons why you think you need international protection. And the questions you will be asked are usually based upon the information you've put in your questionnaire. So it's very important, if you're filling out a questionnaire, to really give as much detail as possible in that questionnaire and set out the reasons why you're looking for international protection. Once the interview is completed, the interviewer and the International Protection Office will draw up a report known as a Section 39 report, which makes a recommendation to the Minister for Justice of Ireland whether, in your case, you should be considered to be a refugee, a person eligible for subsidiary protection, or a person who should be given neither a refugee status nor subsidiary protection status. Once that report has been done, you get a notification from the Department of Justice, usually by mail, which will tell you the outcome of that decision. Now, it's very difficult to say how long that process will take once you've applied. I've acted in cases where international protection claims have taken many years, sometimes 3, 4, even 5 years. In most cases, that actually happens a lot faster, and there's been a large increase in the number of staff in the International Protection Office who deal with these sorts of matters. So the processing times are reducing definitely. Next slide, please. Okay, so what happens then if the International Protection Office refuses you either refugee status or subsidiary protection status? What are your options then? Well, you'd be happy to know that that's not the end of the matter. In Irish law, you have an appeal to a body called the International Protection Appeals Tribunal, otherwise known as IPAT, and you can appeal within 15 days of receiving a refusal of international protection to the International Protection Appeals Tribunal. Now, the format at the International Protection Appeals Tribunal is quite different to the first stage at the International Protection Office. It's much more similar to what you might be familiar with from television or so forth. It's much more similar to a trial. You will have a lawyer acting for you, either a solicitor or a barrister, usually helping you to present your case to the judge or the tribunal member, and there will be a lawyer from the International Protection Office who is there to defend the decision of the International Protection Office and argue that the refusal should be upheld. Legal aid is available, I should have said, in relation to the first stage, the International Protection Office stage, and at IPAT stage. So under Irish law, you have a right for the government to pay for a lawyer to represent you. In practice, the legal aid you get is probably more useful and more meaningful at the appeal stage because it's a full hearing. Typically, at the International Protection Office stage, the legal aid scheme does not pay for a lawyer to attend the interview with you at the IPO stage, whereas at IPAT, you will have a lawyer attending with you and helping you present your case on the day in question. So the scope for lawyers to assist you with your claim for international protection is actually quite a bit larger at the appeal stage than it is at the initial stage. It's also, I should say, very possible, and it's frequently done. I've acted for people who have engaged lawyers at their own expense to present their cases in international protection cases. So there is legal aid available, and you can have the government pay for a lawyer. But if you wish, you can choose to have a lawyer of your own choosing represent you in an international protection case. Next slide, please. So, as I said before, what are the outcomes of international protection? Well, there are 3 outcomes. Firstly, you can be given refugee status. Secondly, you can be given subsidiary protection. And thirdly, you can be refused subsidiary protection or refugee status. And that's if the government considers that you haven't made out your claim to be a refugee or a person eligible for subsidiary protection. And so those are the 3 possible outcomes. I should also say that even if you're not granted refugee status or subsidiary protection, the Minister for Justice considers when you apply for international protection whether you should be given humanitarian leave to remain. And basically that means it often relates to situations where somebody doesn't meet the technical definition of a refugee or a person who is entitled to subsidiary protection, but has some other compassionate reasons or compelling case why they ought to be allowed to stay in the country anyway. And you get a decision on that as well at the end of the international protection process. But I suppose, next slide, please. The big thing I suppose to ask is, now that I've explained to you the procedure for applying for international protection, what is international protection? What is refugee status? What is subsidiary protection? And what do these terms mean? And how do they relate to you? And how should you understand them if you're thinking of applying for international protection? And you'll see there on the slide, the definitions are up on screen. And a refugee means a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group, is outside his or her country of nationality and is unable, or owing to such fear, unwilling to avail himself or herself of the protection of that country. So that's a bit of a mouthful. What does it mean? Well, it means you have a well-founded fear. That means that your fear is real. So it can't be an unreal fear. It can't be, you know, you're afraid of, say, red-headed people, and you say you'll be exposed to red-headed people if you had to go home. It has to be a real and meaningful fear of something like an armed conflict, like the war we have going on in the Ukraine at the moment. So the fear must be well-founded. That's the first condition. The second thing is you must fear being persecuted for reasons of race, religion, nationality, political opinion. Now, all those are pretty straightforward. I think everyone understands those straight away. But the final one is membership of a particular social group. And that's a little bit more complex. And it's a catch-all category. So, for instance, just today, for instance, the European Court of Justice has said that women who have moved to Western countries and adopted Western liberal values, say a Pakistani woman, for instance, who didn't want to wear the headscarf that is normal in Pakistan, and could be a member of a particular social group if she would be forced to practice the wearing of headscarves if she were to return to her country of origin in certain circumstances. So membership of a particular social group is, you know, conditions are characteristics that are not unique to you, but apply to a large group of people. And those characteristics may cause you to be discriminated against or persecuted if you're going back to your country of origin. So that covers refugee status. That's what a refugee is. Now we can talk about this more in questions, because I'm sure people will have questions. The second thing covered under international protection is the second type of protection you can apply for, and that's subsidiary protection. And basically, this status was introduced more recently than refugee status to catch people who mightn't be refugees in the strict definition, but it was still considered by the UN unfair and contrary to human rights to leave those people be exposed. And so the category of subsidiary protection was developed. So a person eligible for subsidiary protection means a person who doesn't qualify as a refugee, where substantial grounds have been shown for believing that he or she, if returned to their country of origin, would face a real risk of suffering serious harm, and who is unable, or owing to such risk unwilling, to avail himself or herself of the protection of their home country. And so the key components here are: you have to not be eligible to be a refugee, and you have to show substantial, when we say substantial, we mean weighty, serious grounds for believing that they'd be at real risk of suffering serious harm. And so the key thing we have to show is that we're at a real risk of suffering serious harm. And what does serious harm mean here? It means that you would be subjected to the death penalty or executed if you returned home. It means B, that you could be tortured or subject to inhuman, degrading treatment or punishment if you were to be returned home. Or C, that there's a serious or individual threat to a civilian's life or person by reason of indiscriminate violence in a situation of international or internal armed conflict. And I suppose it's worth pausing there to say that it would seem to me, based on my experience as a human rights lawyer, that it's subsidiary protection is probably the status that, if you were considering as a Ukrainian person applying for international protection, would probably be the status that you would probably come under, and it would be under C, showing that there is indiscriminate violence by reason of an international conflict in your home country. And that clearly, you know, could, you know, apply to most people who have come from the Ukraine. So obviously, next slide, please. Obviously, you know, now that we know a little bit more about what refugee status and subsidiary protection status here, that raises the question, well, if I'm a Ukrainian person in Ireland and I'm here under the Temporary Protection Directive, is there a good reason for me to apply for international protection? And is that something that I should consider doing? And I suppose there's a few things to consider. The first thing to say is, if you apply for international protection, you can't leave Ireland until your application for international protection has been finally determined one way or the other. And the reason behind that, I suppose, is the theory of international protection is that you say your life is at risk. And so Ireland, if you applied here, is offering you protection for the purposes of considering your application. And so you're obliged to stay here until that has been determined. As it stands, people who are here under temporary protection have the right to work in Ireland. If you apply for international protection, generally you don't have the right to work until 6 months after you've applied for international protection. I think, though, based on my reading of the Temporary Protection Directive, that Ukrainians who applied for international protection in Ireland probably would be able to continue to work during the 6-month period after they applied. I'm not 100% on that, but that's my reading of the law as it stands. So I think if a Ukrainian person was applying for international protection in Ireland, they would probably be able to continue to access the labour market. Thirdly, if you apply for international protection, the default is that you are accommodated in direct provision at the cost of the state. Again, in the case of Ukrainian persons, if you have better accommodation or you have private accommodation, you're not obliged to live in direct provision, and you can provide your own accommodation if you're able to. And I would suspect that Ukrainian people who applied for international protection would probably stay in their existing accommodation. I suppose finally, the thing to consider when applying for international protection, and I've already mentioned this, is that the processing times for international protection are very long, and it can take many years to get a final decision on an application for international protection. So that's something you may wish to consider. That's all I've got to say about international protection for the moment. I have a few further comments to come back to, but if we could move to the next slide now. And the next thing I'm going to talk about is citizenship by naturalization. So this is the process whereby somebody who isn't an Irish citizen can apply to become an Irish citizen. And there are a number of conditions you have to meet. The first is you must be 18 years or older to apply. Now, if you have children who are minors, and you're the parent or guardian of those children, you can make an application on behalf of your children under Irish law for them also to be recognised as Irish citizens. But the bottom line is that you must either be an adult yourself or you must be the adult applying on behalf of a child. So that's the first condition to meet. The second condition is you must meet the relevant conditions of residence before you can apply to be an Irish citizen. That means that you must have the requisite period of what is called in Irish law reckonable residence. Now, not all residence in Ireland is reckonable. So, for instance, if you are here in Ireland on a student visa to study at university, none of the time you are here on a student visa can count towards an application for citizenship. Similarly, if you're applying for international protection, for instance, none of the time you spend as an applicant for international protection can count towards your period of reckonable residence to apply to be an Irish citizen. I should say at the moment, it would appear that time spent in Ireland as a beneficiary of the temporary protection regime is not excluded from being reckonable at the moment. So it would seem at the moment that time spent under the temporary protection directive in Ireland can count towards the acquisition of Irish citizenship. So I suppose that raises the question then, how long do you need? Well, you must have a period of 1 year of reckonable residence continuously prior to the date you apply. And in addition to that, you must have 4 further years, so 5 years in total of reckonable residence, and during the previous 8 years to meet the relevant reckonable residence condition. So just to make that clear, you must have 5 years in total reckonable residence, and for the year immediately prior to your application for citizenship, you must have been living in the state continuously. Now, you can leave Ireland for short periods, a few weeks, for emergency reasons, so it's not a complete ban on leaving the country, but you do have to be present in Ireland to do that. The third condition then is you must have a genuine intention to reside in Ireland and to make Ireland your home in order to apply. So you can't apply for Irish citizenship if you don't intend to live in the country afterwards, and you must give assurances to the Minister for Justice that you do intend to apply. The fourth condition is you must be of good character. Now, that doesn't mean you must be perfect. So, I've had clients who may have had some speeding tickets or some road traffic offences, and they've been adjudicated to be of good character. But basically, you will be asked to fill out a form and declare any or all previous offences or interactions with the police you may have ever had, and you must be very truthful in that. The worst thing you can do in applying for citizenship is to fail to mention something, because then the minister would view it as you trying to hide something from him. So you need to make a very clean breast of it. But generally, you need to have a clean record. And then finally, once you've applied, you'll get a decision on whether or not the minister proposes to grant your application. That can take a long time as well. It can take sometimes up to 4 to 5 years for a decision on citizenship. If you get a positive recommendation, you are then required to attend a citizenship ceremony and make a declaration of loyalty to the nation and fidelity to the state before a judge of the Irish Superior Courts. So that's basically what's involved in an application for Irish citizenship. It's quite an involved process. Some people can do it on their own, but most people who apply for Irish citizenship do so with the help of specialist immigration lawyers. And I've seen many cases where people went wrong because they didn't consult a specialist lawyer initially and try to do it themselves. So one thing I would, and I hope is clear from what I've said, is that immigration law is a very complex, technical, specialist area, and I wouldn't recommend that anyone either apply for international protection or apply for Irish citizenship without consulting an expert. So with that in mind, we might just go to the next slide. So just up here, we have a list. We have listed some logos that give some helpful resources for you if you have further immigration questions. You can see their citizens information website in Ireland is really good for all information you might want to have about interacting with the Irish state. You can also see the Department of Justice logo up there. They're the department who you apply to for immigration matters, and you'll see the Irish Refugee Council there. They assist people who are refugees or applying for refugee status. Similarly, you have the Immigrant Council of Ireland. Obviously, you are all aware of the Ukraine-Ireland Legal Alliance, and we have FLAC, which is the Free Legal Advice Centres. That's where professional lawyers give free legal advice to people, and we have the Community Law and Mediation Centre as well. And then finally, just the next slide before I finish up. And here is just with a view to what I said earlier about immigration being a very specialist technical area. There are two specialist immigration lawyer associations in Ireland. We've got the first one is the Irish Immigration Lawyers Association, otherwise known as ILA. And you have to see the website there. And that is a group of all the specialist immigration solicitors firms in the country. And if you are looking for immigration lawyers in Ireland to assist you, you'll find a very good list of absolutely expert firms there who have a proven track record in the area. And then secondly, you see IACPA, which is the Immigration, Asylum and Citizenship Bar Association. That's my professional association as a barrister. I've put it up there for your information, but you won't in Ireland be contacting a barrister directly. If you need to access a barrister, you must do so through a solicitor. Those are our professional rules in Ireland. So it's really ILA you'd be going to if you want to get some immigration law advice. I should just add finally before I conclude that some of you may worry about the cost of engaging specialist immigration lawyers, and you may have difficult financial circumstances. I should say that many, in fact, the majority of Irish immigration solicitors do work on a so-called contingency or no-fault, no-fee basis. That is to say, they will meet with you, make an assessment of whether or not they think you have a good case. And if they do think you have a decent case, they will act for you and only charge a fee if you succeed in your claim, and they won't charge you fees if you don't succeed in your claim. In practice, what that means is if litigation is involved, oftentimes what happens if you win your case against the Minister for Justice, say if you have a challenge, the government ends up paying the legal fees. So I would just encourage people, if they do feel they need immigration advice, to look at the ILA group, and I'm sure they can help people out. So that just concludes my remarks this evening, and I'll hand you back to the moderator now. Thanks, guys.
Thanks, Angus, and thank you very much to Alina as well.